Good afternoon, everyone. Welcome to the Venable Law Firm. To those of you here in our Washington, D.C. office, and welcome to the several hundred of you who are on the telephone today listening in from across the country, or good morning to those of you on the West Coast. My name is Jeff Tenenbaum. I'm the chair of the nonprofit organizations practice here at the Venable Law Firm. In this seminar today entitled Telecommuting Employees, How Nonprofits Can Avoid the Legal Pitfalls, as many of you know, because I'm starting to see some familiar faces month after month, as part of what has become, since earlier this year, the start of a monthly series on nonprofit legal issues that our law firm has been putting together and will continue to put together over coming months. We do these seminars once a month from 12:30 to 2 p.m. Eastern Time here in our D.C. office, and for those of you who are in the area, we always serve lunches, you know, from 12 to 12:30, complimentary. So feel free to join us if you're ever in D.C. during one of our seminars, but we're glad to have you with us here today. Today's seminar is on a topic that myself and my colleagues here and many others at Venable have been advising nonprofits for years now. So it's not in any ways a new topic or a hot topic, but it's a topic that is just fraught with a ton of legal issues, legal pitfalls, legal complexities. It's an area that seems to get hotter and hotter as more and more nonprofit employers and employers of all types allow and in a lot of instances even promote and facilitate telecommuting by their employees for various reasons. But telecommuting, for all of the great and wonderful benefits that it has for employees and employers alike, really has a lot of very dangerous legal pitfalls. And if you're not aware of those, if you don't take a lot of steps up front to help protect your organizations, you can really create a lot of trouble down the road. So hopefully in our hour-and-a-half program here today, we'll be able to touch on a lot of those issues, answer a lot of your questions, and let you leave here or leave the telephone or the webinar with a much better understanding of the issues. We are very fortunate to have with us today three of my very talented colleagues who are part of our labor and employment group, but who also very regularly work with our nonprofit clients in all aspects of employment counseling and defense and advocacy and all the rest. To my immediate right is Dave Warner. Dave is a partner here in our D.C. office. I've worked with Dave, I think, since as long as I've been at Venable, which has been about 12 years. Dave has worked with hundreds and hundreds of our nonprofit clients in every aspect of employment law, and has become a really invaluable resource to many of them. To Dave's immediate right is Christine Sova. Christine is an associate from our New York office, where she also specializes in employment law and has worked with many of our New York-based nonprofits over the last few years and does a terrific job, and has also participated in a number of these seminars and audio conferences with us. And to our far right is our newest colleague, Nick Ryder, also an attorney from our New York office. We're very lucky to have Nick as part of our team. We're lucky that Christine and Nick both came down on the train today from New York for today's program, and I think they're all going to have some very, very valuable things to impart to you today. A few logistical matters. In terms of questions, we encourage you here in the room to ask your questions throughout the program. Raise your hand. Be patient, because sometimes if our speakers are completing an important point, I want to let them finish before we pose your question. But just let me know as a moderator that you have a question, and I'll call on you. There may be times when I know that we're going to be covering material later on in the program, so I may ask you to defer your question. Similarly, for those of you on the telephone and on the webinar, while we unfortunately don't have we've tried it before and it really doesn't work to open the phone lines to verbal questions. This is too much background noise. But what we do have is a great chat feature on the webinar, which many of you have used very well in past webinars. So feel free to pose your questions throughout. I will be monitoring it on the laptop here at the front of the room, and I'll pose those questions. Sometimes I may modify them a bit, consolidate them, adapt them to whatever the speakers are talking about, but I'll try to pose all of them to our speakers at the appropriate time, either during the presentation or at the end. And we'll try to get to all those. If for some reason we don't get to your questions, feel free to come up afterward. For those of you in the room, or feel free to email any of us with your questions. Our contact information is all on the last slide of the PowerPoint presentation. Speaking of the PowerPoint presentation, obviously you'll be able to see that here in the room and on the webinar, but it also I believe was emailed already to all of you. I think all of you received a PDF version of the PowerPoint already. We will also follow up and send it back out to all participants tomorrow, along with a link to a recording of the session. As you may know, we record all of these monthly webinars that we do and post them on our website, so if you want to share the link with other colleagues or others who might be interested in it, feel free to do so. Finally, before I turn it over to our speakers to get us started, just a quick plug. We do have actually 3 upcoming seminars scheduled. You can always find the listing of upcoming speaking presentations that we're doing, along with registration links, on our website at venable.com/nonprofits/events, nonprofit/events. On October 6th, we'll be doing a program called Nonprofit Strategic Partnerships, Building Successful Ones and Avoiding the Legal Traps. On November 10th, we'll be doing a program called Fiduciary Self-Audits, Evaluating Decision-Making Processes and Controls. And on December 6th, we'll be doing a program called Detecting and Preventing Fraud and Embezzlement in Your Nonprofit Organization. For all 3 of these, we have invited and we'll be including some outside participants. As you know, we try to keep these programs as principally having a legal focus to them, but we like to broaden it out beyond legal issues, and we'll be doing that for all 3 of those. So feel free to participate. They all start at 12:30 Eastern Time. With that, I'm going to turn it over to Dave Warner to get us started. Dave?
Thank you, Jeff. And we'll have our initial technical difficulty of the day. Oh, you have to. Excellent. And we're off. All right, so let's start simple. What is telecommuting? Well, depending on who you talk to and what their situation is, telecommuting is either the greatest thing since sliced bread or the worst idea since the decision to remake Dirty Dancing. Just by show of hands, people in the room, how many of your organizations currently have telecommuting programs? So more than half. How many of you that have the programs either are currently having an issue or within the last year have had issues or problems with your telecommuting programs or telecommuting employees? Not a decent percentage. So, well, telecommuting, essentially what we're talking about are employees that work remotely. That is that they perform services for the employer, but they're not physically located at the employer's place of business. And there are an incredible number of variations of situations that fit within this structure. Some people telecommute just 1 day a week, so it's a part-time arrangement. The other 4 days of the week, they're present in the office. Some have a full-time work-at-home situation. Sometimes it's a temporary arrangement for perhaps personal reasons or for the business needs of the employer. Sometimes telecommuters are located within the same city or within the same state as their employer's headquarters. Sometimes people are outside the state. Sometimes people are even outside of the country. All of these issues have different legal and practical implications for employers, but the consistent thread, again, is when we're talking with telecommuting employees or remote workers, it's employees who just aren't physically located at their employer's place of business. So what are some of the benefits of telecommuting? Well, you really need to look at it from both the employee's perspective and the employer's perspective. For the employee, I think the primary benefit is one of flexibility. And the issue that is raised very frequently is one of commuting time. Those of us living and working in the D.C., Maryland, Virginia area know that commuting can be a real challenge for folks. And so an employee's ability to avoid that, 90 minutes, 120 minutes of the day and turn that into productive time for either the employer or more often for their own family obligations is a great benefit to employees. Oftentimes it allows employees to keep jobs that they might otherwise lose if they have to relocate because their spouse changed jobs or for any other type of personal reason. They may be able to keep their job through a telecommuting arrangement. Similarly, it can be used as an accommodation for individuals with disabilities or as for individuals that might have circumstances that don't rise to the level of a disability but may have a health issue that could be addressed and keep being productive through a telework arrangement. From the employer's perspective, there are also significant benefits. One is avoiding reload. If you have someone who can do the work that you need them to do remotely, you can hire that person whether they live in California, Oklahoma, or wherever, and you don't have to engage the expense of moving them to the East Coast or vice versa. They don't need to uproot their family. It allows us to keep resources. Easy example, an associate of mine, her husband has a clerkship for 1 year. He's going to be located in Illinois. 1 week a month, she's going to telework from Chicago. It's a terrific arrangement because it allows us to keep her employed. She's a great resource, and we would hate to lose her. So the telework and remote relationships can really add to that flexibility. The other thing it can do is reduce spend on rent and other facilities. Once you get past payroll, oftentimes rent is one of the largest fixed expenses that employers have. As this continues to grow with the growth of the internet economy, I mean, many employers have no physical location now, and all of their employees are teleworkers, which creates some really interesting and challenging issues. The thing about the telecommuting arrangement is when it works very well. And I think it is perceived and can be a win-win for both the employer and the employee. The challenge is as we know, it doesn't always work well. So what are some of the principal challenges that we'll be talking about today? The first, I think, is just oversight and management. When your employee is not physically present in the workforce, it just becomes, as a practical matter, more difficult to keep track of that individual's activities, to ensure that they are on task and that they ensure that they are, in fact, working at the time that they say that they work. There's also the challenge of consistency relative to other employees. And you look at the commuting issue. If I had 2 employees performing the same tasks and the same jobs, and I allow Christine to work from home, but I require Nick to fight it out every day coming into downtown, what's my explanation for that? And even if there is a valid explanation, it can still create employee relations problems, so that the issues of consistency and fairness, even short of a legal issue, can really be challenging for employers. And ultimately, there can be discrimination issues that are raised. Well, actually, we'll hold that until we get a little bit later. So what are some of the legal issues? Some of them are quite obvious. How do I comply with the Fair Labor Standards Act as an employer? How do I manage working hours, keep track of hours? What state do I withhold income taxes for? What states do I participate in the unemployment systems for? Some of the issues aren't quite as obvious at first. What if my employee's monitor falls off their table and lands on their foot? What if a neighbor comes over and beats my employee to a bloody pulp during lunch? Sounds made up. Actual case that we'll be talking about a little bit later. Is that workers' comp or not? Yeah, exactly. We hear that a lot. So the objectives today, we wanted. Excellent. We're going to review what are the types of positions that are suitable for telecommuting, and just intuitively, it's obvious that some positions simply can't be done remotely. And we're going to talk through what are some of the criteria or some of the aspects of jobs that make them more or less amenable to a telecommuting arrangement. Perhaps more importantly, what types of employees are more suitable for telecommuting arrangements than others? What are some of the legal implications and considerations for telecommuting? And then finally, we'll get into some practical policy guidance when it comes to putting telecommuting arrangements into place and telecommuting agreements and the like. And with that, I will turn it over to Christine.
Hello, everyone. So before we begin our discussion today about the various legal issues, I just wanted to discuss with you some policy considerations. While telecommuting certainly has its advantages, telecommuting is not appropriate for every employer, and it's certainly not effective for every employee. So whether you're in the process of just simply considering whether to develop a telecommuting policy, actually in the process of developing it or maybe tweaking it, or deciding whether to permit one of your employees to telework, just please remember that not all positions are suitable for telecommuting. So when you're assessing whether or not a position is suitable for telecommuting, you need to consider whether or not a particular job has a specific purpose and whether the respective duties and the job duties are location specific. If you just consider the simple example of a receptionist, that's typically a job that is not appropriate for telecommuting. The receptionist typically needs to be on site to greet guests. Think of, you're not going to have someone who's in a training period sign up for telecommuting initially. On the flip side, there's some positions that are certainly more appropriate, positions where the majority of work involves the electronic transmission of data. That might be something that's appropriate for telecommuting, but again, you need to make sure, and we'll discuss this later, that you're protecting your organization and that you're protecting client and customer information as well. Other characteristics that would make a position suitable for telecommuting involve those involving independent work, those where there's minimal supervision, those where there's limited face-to-face interaction that are required for the job. And certainly a job that is most appropriate for telecommuting are those where there's a specific measurable work product. So you're really looking at, a job where you look at the output of the job, not necessarily the time that's spent on the job. Ultimately, though, as an employer, you're just going to want to make sure that any telecommuting arrangement supports your organization or your department's goals. So that includes productivity, cost effectiveness, and service to your customers and clients. Okay. Another crucial point to remember is that even though a position might be suitable for telecommuting, it doesn't necessarily mean that the employee in that position is suitable for telecommuting. So when assessing any potential telecommuting arrangement, your organization should assess the work style and performance history of the employee that you're considering compared to traits that are customarily recognized as appropriate for successful telecommuters. My apologies here for this particular slide. There's quite a laundry list here, but I thought it would be helpful for you to have this in your materials. But the best telecommuters I've outlined here possess the following characteristics. They're people who are typically organized. They possess excellent time management skills. They're self-motivated self-starters. They have strong written and verbal skills. They work well with limited supervision. They're self-disciplined. They've already exhibited a strong performance record and job knowledge. They've already successfully completed their training phase. They're comfortable using telecommuting equipment. They're comfortable working alone. They're resourceful when handling technology issues. They have the ability to communicate effectively using mixed media, whether it be phones, email, video conference. They have the ability to establish boundaries between work life and home life, and that they have a supportive home or alternative working environment free from household or other distractions. Now, one other related consideration that you should keep in mind, it's not even necessarily is the employee appropriate for telework, but can that employee's supervisor or manager, do they have the appropriate resources and support to effectively manage that person? So that's something you need to consider as well. Ultimately, the best cases for telecommuting are going to be those where the individual employee, the position, and the supervisor and manager are well suited for telecommuting. So we're going to loop back later on in the program to a more focused discussion of policy considerations, but first we want to discuss the legal issues that employers should be aware of when considering telework.
Thanks, Christine. The first thing I want to talk a bit about is wage and hour laws, and for some reason, sometimes this gets lost on employers who have telecommuting employees, is that if the telecommuter is in fact an employee and not an independent contractor, the entire overlay of employment-related laws apply to that individual. They're no less your responsibility to comply with the laws if they're working from home than if they're working in your physical plant. One common mistake we see in this teleworking arrangement is organizations calling someone who should be an employee an independent contractor because they work out of state or because they work remotely. And that has very little to do with the distinction between whether someone is an employee or an independent contractor. It's a factor, but it's by no means a controlling factor. And it's something that employers get wrong a lot because they say, well, we'll just call them an independent contractor because then I don't have to worry about the state laws that might be implicated. If you have out-of-state independent contractors, I would recommend that you look very closely at those relationships. We recently had a seminar on that topic. I know that there's a lot of good materials on the website for that distinction, but it is something that's rolled in when we're talking about remote employees.
And let me just interrupt you for a second. For those, this is not, obviously today's seminar is not principally focused at all on the Fair Labor Standards Act and the wage and hour laws or on the employee versus independent contractor issue. But for those of you who have been following our seminars, those were actually the topics of two recent seminars and webinars that we did. One was one that Dave participated in regarding employees versus independent contractors, and the other one was one that a couple other colleagues from our labor and employment group did on compensable time issues for non-exempt employees and what time has to be counted as compensable and what doesn't. Both of those were very, very popular, very well attended. We've gotten some great feedback on those. Fortunately, both of those are recorded and available on our website along with the PowerPoint presentation. So if you go to that same link I gave you earlier, venable.com/nonprofit/events, if you search under topic area employment law, you'll see a listing of all of our past seminars on this, and you'll be able to find those and listen to those recordings there.
Okay, thanks. Yeah, and one of the principal challenges with telecommuting employees is wage and hour compliance. Under the federal law, employees who are non-exempt are entitled to overtime for any hours over 40 worked in a work week. Virtually every employer is aware of that obligation. It's on the poster that's sitting in your employee's break room or otherwise. It's on the federal mandatory poster. What many employers that don't practice or don't have operations in multiple jurisdictions fail to realize is that states have varying wage and hour laws, and some states have daily overtime requirements. Some states have weekly overtime requirements that don't line up with the federal laws. Some states like California have incredibly complex wage and hour systems that need to be complied with. The other major issue is just keeping track of the time that is actually worked. Everyone on the dais here has been participated in wage and hour and FLSA litigation, and I will tell you, not having solid evidence of time actually worked is a huge evidentiary hurdle for employers. So whether the employee works at your physical plant or remotely, it's essential that we have some mechanism for keeping track of hours worked. So what to do? One option is to only permit exempt employees to work remotely. And those are our salaried exempts, administrative, professional employees, or executives that aren't entitled to overtime. It avoids the overtime issue entirely, but quite frankly, it may not be practical because the individual that you want to retain or want to engage may not fit within any of the exempt categories. The other issue, or another issue, is one of fairness. Again, the optics of it. If I'm forcing all of my hourly employees to tough it out around the Beltway, but I allow my director of marketing to work from home, that's going to create an employee relations issue for me, regardless of whether it's a legal issue. And having a system where only my exempt employees can work can lead to issues of disparate impact. As the labor market grows increasingly more diverse, we still see more diversity in the non-exempt lower-level employees. And so if you have a system or you have a practice that only exempt employees are eligible to work remotely, one of our clever friends on the plaintiff's bar could be able to gin up a case that I think would pass the straight face test, that policy could have or is having a disparate impact on women, minorities, or any other protected category. I think, as I said before, it is necessary, I think a necessity, to have some system of monitoring remote workers' hours. So having some clocking in or clocking out mechanism. And this can either be handwritten sheets, or I prefer things like log in and log out times, checking in online. There are many, many tools that are available because most of our workers, and particularly most of your teleworkers, are going to be working on computers and likely are going to be coming in and logging into your network. So there are tools that are at your disposal, such as keystroke counts and other tools that allow us to see if someone is on task or off task. And I encourage you to work with your IT departments or IT vendors to figure out what is going to be most effective for you. The other important piece there is to make certain that your remote worker knows that you're doing that. So when we talk later about agreements and policies, having it open and acknowledged between the employer and the employee that we are going to monitor your productivity, and we may do that through tools including monitoring the network, monitoring emails, monitoring keystrokes, et cetera. All of that is completely legal, and you could likely do it even if you didn't acknowledge it, because they are your agent, they are using your tools and your network, but you're in a much better position legally if you're just upfront with the employee and say, this is how we are going to do this, because you are still our agent. You might be in your basement, in your boxer shorts and fuzzy slippers, but you're on my dime. And so I get to keep track of your productivity.
Dave, we have a question from the folks on the phone. Certainly, if we're dealing with non-exempt employees, monitoring and tracking their actual hours worked is not only critical, but it's not only allowed, but it's critical to do in order to avoid paying unnecessary overtime, regulating hours and making sure they're working the hours they're supposed to. But the question is, what if you are doing the same with exempt employees and tracking their hours? Do you run the risk of converting an exempt employee into a non-exempt employee?
It's a good question, and the answer is you don't, as long as the other indicia of an exempt employee are in place. We get that question a lot, particularly in the greater D.C. and Virginia area where we have a lot of government contractors, and you have many exempt employees who are actually billed out on an hourly basis to the government customer or to a prime. There's nothing in the FLSA that says I can't require my exempt employees to track their time. Total time accounting is very common in that industry. The problem is one of optics, because it does make the employee begin to feel as if they are an hourly employee, because if I'm exempt and you can force me to work as long as I need and I'm not going to get any overtime, why do I have to keep track of my hours? There are good reasons even for folks who aren't in the government contracting space. For example, FMLA, you have to keep track of the hours worked to know whether they've worked 1,250 hours in the last 12 months and are eligible to take that leave. And the other is it's just an effective tool for making certain that you're getting value for your money, that people really are staying on task. So it's perfectly legitimate to require exempt employees working at home or in your physical space to keep track of their hours worked. So that's not a concern, again, so long as the other indicia of an exempt employee are there. One issue is overtime. And you see on the slide, do we want to prohibit overtime without prior authorization? The answer to that question is absolutely yes. For our non-exempt employees, we do want to prohibit them from working unauthorized overtime. However, and this is a very large however, if they do work unauthorized overtime, you have to pay it. And that is a common mistake, because people think, well, I didn't authorize them to work the overtime. Why am I having to go out time and a half? And the answer is federal law requires it. You have to pay the overtime, and you address that issue on a disciplinary basis, not on a financial and wage payment basis. The next issue I want to talk a little bit about is occupational safety and health, so OSHA. And OSHA has had a curious legal history when it comes to telecommuting. What people often fail to realize, because our lives seem to be completely inundated with laws and regulations, and be it at the state level or the federal level or the agency or Congress, but the fact of the matter is that laws trails the economy, it trails the labor market, and in a very real way it trails reality. When the laws that OSHA enforces were created, the concept of people working from home simply didn't exist. And so what we have is a framework of laws that was never designed really to address the modern realities. And it's continuing to evolve. Where we are currently is OSHA, certain requirements of OSHA do apply to your home workers or to telecommuters. So for example, if a telecommuting employee suffers a workplace injury, their computer collapses onto their foot, that would be a work-related injury that would be subject to reporting obligations. However, not all of the obligations of OSHA apply. There was a tremendous amount of discussion and debate in Congress and at the agency level several years ago about inspections, and whether or not it's incumbent upon an employer to inspect a telecommuter's work site to make certain that it's safe. Because generally speaking, I as an employer have an obligation under the law to provide a safe working environment. And that common law obligation still would apply to a telecommuting work site, arguably. But the federal law has evolved in such a way that there is not an obligation on the employer to affirmatively investigate and inspect a telecommuter's work site to ensure that it meets all of the safety obligations that OSHA puts into place. As you see on the slide, one of the issues is that we can still be held responsible for the tools that we provide, the processes that we require, or the methods of work that we require the employees to use. So from a policy standpoint, that creates an incentive for employers not to provide the tools that are required to work if that's capable or if that works in a given working environment. So for example, it would be one thing if I have provided the desk, I've provided the computer, I've provided the fax machine, et cetera, and something happens to that equipment and causes a workplace injury. I then have obligations under the law because I'm requiring you to use my equipment. If, on the other hand, my only requirement is that you have a computer that's fast enough and an internet connection that's fast enough to talk to my network, and everything else is on you, I've shrunken my obligations under OSHA. And so it is a policy consideration. Some employers, it's simply not feasible that for whatever reason, be it proprietary software or proprietary computers, that you have to provide the tools. But if you don't have to provide the tools, there is some benefit to saying, you, Mr. or Mrs. Employee, you're responsible for your workspace, and you're responsible for providing your tools. Related to the safety issue in OSHA is workers' compensation. Now, workers' comp is, oh, sorry, is there a question in the back?
Slightly away off the occupational safety and health, but if you are using your own, if your employee is using his or her own computer, can you as an employer require them to forbid other people in their household from using their own computer that is being used to access the corporate network? Children bringing home, kids bringing home districts, or some driving to school and plugging it in and getting to the network to sort of things up.
Yeah, it's a good question. I'm sorry. Yeah, and for the folks that are online, the question was, can I as an employer require that or limit the number of people who can use the computer that's being used to access my network? And the answer is that you can. And that there's very good reason to do that because of given the viruses and the ability to zombie computers and for people to access computers remotely. In a perfect world, what you would require is having a computer that will only be used for work purposes. So that is certainly lawful. The problem is, or the issue is, it's a difficult rule to enforce. But that does not mean that you shouldn't have it and try to enforce it and discipline employees when it's found that it hasn't been followed. Yes, question.
Question on this on OSHA. So even beyond telecommuting, a lot of employees will take laptops home every evening or might do a little bit of work from home and the laptop falls on their foot or they strain their back carrying a laptop home. Would that potentially also fall under OSHA?
It's conceivable that it would. It's more likely to be a workers' comp type issue. Oh, I'm sorry. The question is if the for folks not telecommuting but having the computer that they take with them and they strain their shoulder or drop that on their foot, would that conceivably be an OSHA issue? The short answer is it's far more likely to be seen as a workers' comp issue. Now, if your computer bursts into flames and burns down the house, then that begins to look more like an OSHA issue where it's one of the tools that was defective as opposed to just an injury that relates to or arose within the context of work. Yes, sir. Another question.
Yeah, David, as a veteran of both the State Department, where everybody is TSSCI cleared, top secret, secure, compartmentalized, and interior, the question that was just asked is almost always, my experience of 15 years with federal agencies, you do inspect the home, provide the equipment, and therefore you're not subjecting yourself to that gray area. Well, if you make the person have a unique computer for the teleworking, obviously that's the same. You probably have to pay for it, so it's the same as you're providing the standardized equipment for the system. So, in particular, where you're accommodating somebody with some type of a disability, letting people work at home because they're subject to seizures and could wreck their car coming to work, et cetera. You certainly want to be sure that that home workplace is not going to fail to eliminate the risk you're trying to avoid in the first place.
Yeah, I think just for the sake of the folks that are online and don't have the benefit of that comment, I think I would summarize it by saying that in different circumstances, there are going to be different answers to the question of do you inspect an employee's at-home work site or do you put the onus on them? The comment that we had was from an individual who has a lot of experience in the federal workforce. There, they do undertake the obligation to do home inspections, provide all of the equipment, et cetera. For many of the clients that we deal with, including many, if not most, of the ones that are in this room that have smaller employment workforces, more limited resources, that may not be available even as an option to do that. But again, the issues surrounding the safety and the like are ones that do vary depending upon the circumstances. But again, the OSHA compliance piece is certainly there.
And I think we're going to need to move on. Keep your questions, though. We'll have time to get more later. And if I could ask everyone in the room here to try to keep your questions as brief as possible, just so we avoid as many kind of pregnant pauses on the phone for the folks dialing in. Thanks.
Sure. Back to the workers' comp piece, again, it's uniquely a creature of state law, and there's a great deal of variance among them. Generally speaking, an injury is going to be compensable if it is sustained in the course and in the scope of the job duties that the employee has. Now, there are practical problems to the workers' comp issue when you're dealing with telecommuters. Principal one is lack of witnesses. And this sort of loops back to making sure that you've got the right person that you're permitting to telecommute, and you haven't just given a serial litigant the right to work at home and claim to have an injury that they're now going to tie you up in workers' compensation for. Other practical problems, how do you investigate? I mean, it's one thing, can you require that the employee permits you to enter their house to investigate? What if the employee is across the country? As a practical matter, how do you go about investigating what happened? And this is an issue that has given rise to some truly bizarre fact patterns in the law. And the case I mentioned earlier was a case in Tennessee, and it was an at-home worker. She worked remotely, I believe, for a company that was in New York, and had her home office. And she stopped to eat lunch, took a lunch break, was making lunch. Her neighbor comes over, knocks on the door, lets the neighbor in, and for whatever reasons, the neighbor assaults her and brutally beats her to the point of unconsciousness. Now, intuitively, we would think this has nothing to do with workers' compensation. Her lawyer disagreed with that suggestion and filed for workers' compensation. And the issue went all the way to the Tennessee Supreme Court. And the Tennessee Supreme Court did hold that within that context, that was not a compensable injury. But it was not that clear. It was not a completely clear line. And what the Tennessee Supreme Court said was, it's not compensable here because it is a neutral assault, meaning that the assault had nothing to do with the employer and employee relationship. But there could be liability if there was an argument to tie the assault back to the relationship, to the work relationship. So, for example, many nonprofits and associations are involved in public policy and advocate political positions, which may not always be popular with certain segments or with other segments of society. So if this individual worked for one of those organizations and the assault was by some zealot that had a view that differed from the one of the organization that she worked for, using Tennessee's logic, that would be compensable. So it's an extreme example, but it just goes to show that, one, workers' compensation absolutely applies to individuals that work from home, and there can be a nexus, if there's a nexus between something that is seemingly random and has nothing to do with the workplace relationship, you could still be, if not liable, you could certainly have an obligation or an issue that would need to be litigated, sometimes quite surprisingly. Wrapping up on the workers' compensation, and we talked a bit about this, periodic investigations of the work site, should we require them? Again, I think reasonable minds can differ on that, and it has to deal greatly with available resources and the practicalities of it. I think it really does cut both ways. Similarly, having a policy of a mandatory inspection if there's a workplace injury. It sounds like a good idea. My hesitancy there is anytime that there's a mandatory a policy that says management will or the employer will, it makes me uneasy. I think what I would prefer to have is a policy that would say if you suffer a workplace injury, the employer or we have a right to come and do an investigation, but that's still discretionary on our part. We're not saying that we absolutely will come and do that because, again, I think we want the flexibility to make a reasoned judgment at any time whether or not we want to engage or have the cost and the disruption of doing the investigation. So with that, I'm going to turn it over to Nick to talk about some of the implications of the Americans with Disabilities Act.
Thank you, David. Good afternoon, everyone. I'll be speaking about 3 topics today, the first of which, as David mentioned, are telecommuting issues that arise under the ADA, otherwise known as the Americans with Disabilities Act. And just as a brief overview, as most of you probably know, the ADA prohibits discrimination that's based upon an employee's status as disabled. And so the first question with any issue under the ADA is whether the employee meets the definition of disabled under the statute. There's generally 3 ways that an employee will be considered disabled. Most typically, they'll have a physical or mental impairment that substantially limits one or more major life activities. For example, the employee may be restricted to a wheelchair. The employee may have extremely poor vision, any of which disabilities that might restrict some of their major life activities. The second definition of disabled under the Act is that having a record or a history of such an impairment. A little less common, but another example is take a cancer survivor. A cancer survivor might be cancer-free. They have a history of having undergone chemotherapy and other treatment, but maybe they're applying for a job now. And the employer is concerned because of this history of cancer treatment that the cancer might return, that the job applicant might be absent for an extended period of time. That might expose that employer to an ADA claim if they discriminated against that job applicant because of that history of cancer treatment. And the third way that an employee might be considered disabled under the ADA is that they're not in fact and in reality disabled, but for whatever reason the employer misinterprets or incorrectly regards them as having a disability. Now, with respect to telecommuting issues, oftentimes a disabled employee might approach their employer and might ask for the option to telecommute as what's called a reasonable accommodation for their disability. And under the ADA, employers with 15 or more employees must reasonably accommodate disabled employees. So an employer might be put in the position where they're required to offer telecommuting as an option to a disabled worker. The only exception is when this reasonable accommodation might constitute an undue hardship, or if telecommuting will not allow the worker to perform the essential functions of his or her job. So one question that employers need to ask themselves when an employee approaches them and requests telecommuting to accommodate their disability is, of course, whether the employee can still perform the essential functions of his or her job from his or her home. For example, does the employee making the request regularly do client intake? Do they regularly meet or greet clients or customers? Does the employee regularly meet with teams of other employees face-to-face? Maybe the employee is in a supervisory role and they need to be on site to evaluate the job performance of subordinate employees. Or just overall, is there a strong basis for believing that the employee's productivity or the quality of work might suffer? At the end of the day, the employer needs to ask whether the employee's presence at the work site is going to be critical for the employee making the telecommuting request to perform the essential functions of their job. One thing to keep in mind, of course, is that the more and more an employer permits telecommuting for other employees, especially disabled employees, it's going to be more difficult for an employer to justify that the telecommuting request constitutes an undue hardship or that this employee is incapable of performing their essential job functions in light of the fact that other employees are permitted to telecommute. So what to do in light of these issues? Some of the policy considerations, and perhaps one of the most important, is for an employer to review their written job descriptions. You should look back to your employment policies, your employee handbook maybe, and see whether the essential job functions for each position are clearly stated. That way, an employer can turn to those job descriptions and can point to those job descriptions when justifying a decision to deny a request for telecommuting for a disabled worker. Second, perhaps just as equally important, is to engage in the interactive process. An employer is obligated to communicate with an employee who is disabled who requests a reasonable accommodation. Telecommuting doesn't have to be the only option to accommodate a worker's disability. You might want to consider alternatives if there's good reason for not allowing a worker to telecommute. One recent case involved an employee who requested telecommuting because he suffered from seizures. And when he got stressed at work or he felt the onset of a seizure, he needed to lie down for a couple minutes to prevent the seizure from accelerating. He requested telecommuting, but the employer offered to put a cot in the employee's office, and that was upheld as a reasonable accommodation, as an alternative to the employer's telecommuting request. The third policy consideration is to require medical certification for the need for telecommuting. Oftentimes an employee will request telecommuting as a reasonable accommodation, but they won't have seen a physician explaining the need for the request. Yes, ma'am.
If you have an employee who has difficulty getting to work because of a disability, can you ask them to telecommute so they can go home and do their work at home?
The question is, if an employer observes that an employee has a disability and is having difficulty coming into work, if you can ask them to telecommute as an option to deal with that disability. You can certainly suggest it. You'd want to be cautious, of course, of discriminating against them on account of their disability, especially if they're still able to perform the essential functions of their job. If they're not able to perform the essential functions of their job, and that's what initiated the discussion in the first place, then that would be part of the interactive process that you would commence with the employee. So you can certainly raise it with them, but you want to tread lightly upon any discrimination issues on account of their disability. Any other questions before we move on? So the next topic I'd like to discuss is how to administer your telecommuting policy in a non-discriminatory manner. As most of you probably know, the federal and state laws prohibit adverse employment decisions based upon an employee's membership in a protected class. And protected classes can range from race and national origin, to religion, to gender, to age, marital status even, among others. And generally speaking, the two types of discrimination claims that we see, and that David actually alluded to earlier, are disparate treatment claims and disparate impact claims. The two are very different. A disparate treatment claim is an intentional form of discrimination. That's an example of when maybe a minority employee feels that he was disciplined more severely than his non-minority counterpart, and he feels that it was a decision made by his supervisor on account of his race. Or perhaps a female worker was passed over for a promotion and a male worker received the promotion. Meanwhile, she can show that she was more qualified for the promotion. Those would be the traditional forms of intentional discrimination that would constitute a disparate treatment claim. Conversely, a disparate impact claim is a form of unintentional discrimination. It's usually an organization-wide policy that's neutral on its face, but that has a disproportionately adverse impact upon members of a protected class. For example, maybe an employer has height and weight requirements for a position for whatever reason, and those height and weight requirements exclude a large number of female applicants. However, some of those female applicants can show that they're still capable of performing the requirements of the position. That would be an example of a disparate impact claim because you have a facially neutral policy that had an adverse impact, disproportionately so, on female applicants. Now, with respect to telecommuting, disparate treatment claims can be pretty obvious. A minority worker requests the option to telecommute, but for whatever reason, the employer denies that request. Meanwhile, a similarly situated employee who's not a minority worker, gets their request granted. That's why it would, of course, be important to have non-discrimination training and policies in place so that anyone making decisions for telecommuting requests were wary of any potential liability for disparate treatment. On the other hand, disparate impact claims, assuming there's no intentional discrimination occurring, are far more likely for telecommuting issues. For example, perhaps an employer requires that all telecommuting employees have a room in their home solely dedicated to the workspace. And this might be for obvious reasons, you think. They don't want any distractions for their telecommuting workers. They don't want their workers, David alluded earlier to sitting in your boxer shorts at home. That might be very comfortable for the telecommuting employee, but you don't want a telecommuting employee doing most of their work in the living room in front of the TV or with their child on their lap while feeding them breakfast in the kitchen. You might want all telecommuting workers to have an office solely dedicated to work time, because the theory is that you want your telecommuting worker to be just as productive as the workers at your workspace. However, even though it sounds harmless, depending on the socioeconomic conditions for an employer and the employer's workforce, maybe only the more affluent employees for an employer can afford to dedicate an entire room within their residence to a workspace. And maybe only white workers are among that higher socioeconomic class, or maybe they're only male workers, or maybe they're only single workers, non-married workers, who can afford to do that with their homes. And so as the percentages of those workers increases, the employer might be subjecting themselves to a disparate impact claim for members of that protected class. So some of the policy considerations for a telecommuting policy in light of the federal and state discrimination laws is first to identify, at least internally, what positions are available for telecommuting. This is going to be important so that an employer can later say that regardless of any employee's membership in a protected class, that telecommuting for justifiable business reasons is not available to that employee. The second is to make a decision internally whether all employees within positions that are eligible for telecommuting are going to be able to telecommute, or alternatively, perhaps an organization, an employer wants to determine that only a percentage of employees within a certain job classification are going to be able to telecommute. And after making that decision, the employer will want to decide whether it's on a first-come, first-served basis or whether it's going to be a blanket policy for all workers within that job classification. This, too, if there is a claim filed, is going to provide the employer with a strong basis for demonstrating that their decision had nothing to do with the employee's membership in a protected class. Third, the employer really should try to document the decision-making process as much as possible. They should try to detail how the telecommuters are selected internally, how the decision-making is made by management. They should have a standard request form for all employees who are submitting telecommuting requests. And you can even have on that form a section in which the requesting employee has to justify why they can still perform their job just as efficiently on a telecommuting basis. And very importantly, the employer should have a written record of all decisions regarding telecommuting requests. And when the decision is a denial of the request, it should state clearly the basis for the denial. Another consideration is to ensure that all compensation schedules and benefit programs are uniform, both for telecommuters and non-telecommuters. Again, as I mentioned earlier, the idea is that telecommuting employees are going to be providing and producing just as good work product as anyone who's working at the employer's location. So hand in hand with that, they should be treated the same and have the same benefits. And last, it's always a good idea for an employer to evaluate their policies as well as their decisions with regard to telecommuting requests, see if there's a high number of members in a protected class that are having their requests denied for one reason or another, to evaluate whether perhaps there's large members of a protected class that are within a certain job classification. for which telecommuting is unavailable. The final topic that I'd like to discuss are legal implications for telecommuting employees under the Family Medical Leave Act, or the FMLA. Just as an overview, qualified employees under the FMLA are permitted up to 12 weeks of leave time during any 12-month period. And this can be for any of three qualifying reasons, which would include that the employee has suffered a serious health condition, perhaps the employee recently gave birth to a new child or adopted a child, or the employee needs to care for a spouse, a child, or a parent. And this will apply to the employee, one, so long as the employee worked 1,250 hours within a 12-month period, but also the employee has to work at a work site that either has 50 or more employees, or at least 50 or more employees are employed within 75 miles of that work site. And for telecommuting employees, one issue that arises is what constitutes the employee's work site. Because remember, they're working at home, but they otherwise would be working at an office. Or is it the employer's principal office? An employer might have a principal office located in one state, a regional office located in another state, and in an extreme example, the telecommuting employee could be located in a third state. So where's the employee's work site for purposes of determining whether the FMLA applies and whether they're eligible for leave? And under the FMLA, in recent case law, an employee's work site is the office to which he or she reports and from which he or she receives assignments. Now, it's very tempting for an employer to, when an employee requests FMLA leave for any of those reasons, maybe they're suddenly sick, or maybe they're caring for a relative, or they recently gave birth to a child, it's very tempting for an employer to ask that the employee telecommute in lieu of taking FMLA leave. But employers should be cautioned. That can be seen by courts as an interference with the employee's right to take leave under the Family Medical Leave Act. What employers can do, however, is they can offer that the employee work on a reduced leave schedule. For example, that the employee telecommute maybe 4 hours a day, twice a week, while they're out on leave. But it's imperative that employers recognize that this can only be optional. It can't be mandatory. And similarly, in terms of the 12-week allotment under the FMLA, it's only the actual time that the employee takes. Just because they take a portion of the week out on leave, that doesn't mean they've taken that entire week for their 12-week leave time. Finally, just for some policy considerations, it's important to identify the types of employees who are going to be appropriate for a reduced leave schedule, for the option that employers have under the FMLA to offer telecommuting. Obviously, if an employee needs to take FMLA leave, say, to care for a child or because of the birth of a child, if they have a spouse who's able to share in some of the responsibilities for that care, well then a reduced leave schedule is going to be appropriate for that employee. On the other hand, if they've just suffered a serious health condition, you know they're going to be incapacitated for a long time, or you know that they don't have someone who can, if they can't seek daycare, say, for the child, or if they don't have someone who can share in the responsibilities to provide care at home, then obviously telecommuting isn't going to be appropriate for that employee. And with that, I will turn it back over to David.
Thank you, Nick. I'm going to talk a little bit about privacy issues and privacy concerns. We saw back when the discussion about the OSHA that privacy is always an issue when we're dealing with telecommuters, particularly those that work out of their home. And a lot of the discussion around the question of would the OSHA investigation rules be pushed out to reach telecommuters revolved around the notion of there was something unseemly about employers being able to invade the privacy of an individual's home. And privacy is an issue that the states treat very differently, and privacy law is continually evolving. But generally speaking, when we're talking about the employer-employee relationship, the issue of privacy reduces to what's the employee's reasonable expectation. And this is an area where employers want to be and need to be very proactive from a policy and a practice standpoint. Because what we want to ensure is that our employees' expectation of privacy is unreasonable. And what I mean by that is, to the extent the employee is using a computer to access your network, or if they have their personal cell phone or personal PDAs, and as PDAs become more and more powerful in terms of their computing ability, it's very likely that our employees are going to be using their personal handheld devices to access your networks and to do work on your behalf. And what we want to have in place, or what we ideally want to have in place, is a policy and an agreement and understanding with the employee that, to the extent we don't own the machine, if it's their computer, if it's their PDA, if it's their phone, if they're using it to conduct business, we have the right to access it, to review it, and if we deem it necessary, to wipe it. Although I will say, before you delete any data, you should be real certain what it is that you're deleting, because deleting data can cause all sorts of legal issues that are well outside the scope of this particular discussion. We're talking about monitoring a while back about how we keep track of time. Obviously, that has privacy implications. I think we definitely do want to have tools in place to monitor our at-home workers and making certain that they're on task and actually working. Could we video them? I will tell you that makes me a little queasy, but it's probably not per se illegal to have a cam that is either behind the employee, or have them have their, if they've got a computer that's early enough that has an integrated camera, to have that open. So if I wanted to click in, I could see that, yes, indeed, they're in front of their computer typing away. Again, outside the scope of this topic, but there's a lot of law in the labor and NLRA, National Labor Relations Act context around surveillance of employees. So if you are going to be engaged in anything that has the whiff of surveillance, you want to be sure that you work either with a very sophisticated HR personnel or your employment counsel to ensure that you're not stepping into an issue. I know many of you may be thinking, I don't have any NLRA issues because I don't have a labor union. It actually applies to every employer that employs anyone. The National Labor Relations Act has a very large reach, and simply because you don't have a collectively bargained workforce does not mean that the rules regarding surveillance and the like don't apply to you.
And just one side note, there have been two recent very notable developments under the National Labor Relations Act regarding employers' ability to having to do with social media policies governing employees and the ability to discipline employees in connection with their use of social media. And we put out two recent alerts, myself and a colleague, Ron Taylor, writing about these developments. For those of you on our email list, you would have gotten a copy, but you can find that on our website. It's something very much worth taking a look at, and we hear constantly from so many nonprofit employers that say, well, I don't have to worry about the NLRA because we don't have any unionized employees, but as Dave indicated, that's definitely not the case.
And even though I didn't write those, I really do commend them to you for your reading list, because that intersection of employment and social media and labor law is, again, one of those areas where the law is beginning to catch up and is just starting to analyze those types of issues. It is something that I expect is going to continue to grow and continue to be an area where our friends on both the plaintiffs' bar and our friends at Union Council will continue to push. I believe there's a question in the back. Yes, sir.
So this standard of reasonable expectation of privacy was at least originally developed in kind of a Fourth Amendment sort of context. And so with the exception of a government employer, does the standard apply sort of the same to between private parties?
The question is, is the standard a Fourth Amendment standard, or what is the standard between private parties when we're not dealing with a government actor? And the answer is, in the employer-employee relationship, the expectation of privacy is more of a common law standard.
But that was also common law too.
What's that?
In the Fourth Amendment context, of the reasonable expectation of privacy was also common law.
Yeah, originally the Fourth Amendment obviously had its growth in the common law, but there's the Fourth Amendment jurisprudence is a creature of constitutional law. The privacy jurisprudence that applies to the employer-employee relationship is going to be a creature of state law, because it is those common law duties. So there may very well be actions that an employer might take, be it in this context or any other context, that might be perfectly valid in Virginia, for example, but would violate the right of privacy that's been developed in West Virginia. So when you're dealing with issues of privacy, it's important to focus not only on whatever the law of the state is where you are presently or where your headquarters is, but understand what the law of the state is and where the lines are in terms of the right of privacy and the jurisdiction where your employee is located as well. Yes, ma'am.
What does it say for Washington, the law?
The question is, what is the law of privacy in D.C.? It can't really be answered in a vacuum, but I would say that it does follow sort of the common law expectation of privacy, and is that expectation a reasonable one? And that's why the policies and practices and agreements in this context are so important, so that it's understood. So if we are going to monitor as an employee's computer usage, for example, that we have an agreement and a policy that says we are going to do this, and then I have a policy that says we can monitor, and then I have an agreement signed by the employee that says I understand that you will have the right to review my email and to review my internet usage, during working hours, et cetera.
And no matter what state or jurisdiction you're in, if you make very clear to your employees that they have no reasonable expectation of privacy and you are going to monitor, or you reserve the right to monitor and inspect and things like that, then in any state that's going to go a long way toward reducing any reasonable expectation of privacy.
Right. And then I think employers would also be well served to make use of the continuing improvements in telecommunications and tools like Skype and the like, where and have regular check-ins with telecommuting employees, so that there is, be it a daily or some regular check that you can get management and the employee together online and actually see each other and discuss and have the virtual meeting, if you will. I think that those types of regular check-ins are important. And again, as Jeff said, having the policies and agreements that are reduced to writing go a long way towards resolving any of the issues that might arise in this context. Protecting confidential and proprietary information. Obviously, in a remote relationship, it's more difficult for me to ensure data security. So we would want to take extra precautions. For people that are located in my physical office, I have control of the physical space. I can have door badges and locks and security, and I know who's coming in and out. I don't have that same ability when I have a telecommuting employee. I don't know who's looking over their shoulders. So you do want to take some extra steps. One would be affirmative non-disclosure agreements, confidentiality agreements, an agreement like we talked about before that a given computer would only be used for business purposes. If people are dealing with highly sensitive information, agreements that no one else can be present in the working environment while they're working. All of those things, I think, are tools that are in the toolbox and may or may not be necessary depending upon what the employee is actually doing for you and the sensitivity of the data that they're working with. The dedicated equipment piece is one that I think can and should be pitched to your employee as a benefit both to the employer and to them as well. One of the issues that comes up when we're in employment litigation, and particularly in the context of non-compete litigation or trade secret litigation, where you have an employee that leaves company A to goes to company B, and company A says they took my holy grail with them, they downloaded a bunch of information, and now we're going to have a lawsuit about that. Discovery is always as broad as the lawyers can make it. I mean, that's one way that we increase the pain to the other party, and we love information and data. We want to get as much as we possibly can because there might be something in there that's useful to me. So if I'm representing company A, I'm going to serve discovery on the company, and I'm also going to subpoena the individual who left. And I'm not just going to ask for his files from his work computer. I'm going to ask for his personal computer as well. And if I can develop evidence that says he used his personal computer to work for me, or he's now using his personal computer to do work for company B, there's a decent likelihood that I'm going to get access to the data that's on his personal computer. So when you're explaining these tools, or rather these policies to your employees, I think it's fair to explain to them that this is not only for my protection as the employer, it's for your protection as an employee, that if an issue were to arise that relates to your employment, anything that you use to conduct business for us is potentially fair game. And anything that's on your computer, be it something that you did, your kids did, your wife did, whatever, it could potentially be disclosed. And so it's a way for them to protect themselves from what can be a real invasion of their privacy. And can generate some significant fees and pain in discovery disputes and the like. The last piece I wanted to mention was restrictive covenants. You want to make certain that you're modifying these to reflect the reality of telecommuting workers. So for example, if you have a standard covenant that you use that says you can't compete with us within a 50-mile radius of our headquarters, if the employee works 250 miles away in California and can still adequately compete with you from there, your non-compete's worthless. And so you need to make certain as to add to the protection to your data and to your operations that you ensure that those covenants are modified and to reflect the operational realities of the individual's employment. Finally, a quick word about tax and wage issues. This is another area where there's significant evolution and continuing evolution under the law. The simple fact is that state governments are desperate for income, and they're becoming ever more aggressive about finding new pots of money and asserting authority to tax income. And so, for example, in New York, there was a traditional rule that they would only tax income that was generated within the state. So there was a case where you had an employee, I believe they worked in Colorado, and spent 75% of their time in Colorado and 25% of their time in New York. And for years, it was 75% of the income was taxable in Colorado and 25% was taxable in New York. Well, the New York government decided that, well, wait a second. This relationship was actually not for the convenience of the employer. It was being done for the convenience of the employee. And so all of that income, they felt, should be taxable to the New York employer because it was the employee's choice to remove that, what otherwise would have been income to New York, to remove that to a different jurisdiction. And that was found to be constitutional. And so that 100% of the employee's income could then be taxed by New York. And it could also arguably be taxed by Colorado. So you have a double taxation issue. Now, again, this is an issue that's continuing to evolve, but just when you have the remote workers, you need to have sophisticated counsel look at it and make certain that you're in compliance, or at least know where potential liabilities or potential issues could arise. Yes, question.
So with these tax issues, sort of to the example that you just gave, is this something that affects obviously remote full-time employees, but is there some sort of cutoff when you're looking at tax, whether if they're working X amount of time from home and X amount of time in the office?
And I'm not a tax specialist, and so what I will call my layman's understanding, it has to do with the nexus with the state. Now, there's a federal law that says that if you have a single employee that the only thing that they do is solicit sales in a different jurisdiction, that's not a sufficient nexus for the corporate entity to be subject to taxation in that state. Once you get out of that context, I think it's fair game for the state to take the position that this company now does have a sufficient nexus. You are conducting business within our borders, and turns out we need money, and we're going to take the position that you're now subject to corporate taxation here. So it's another issue where, thanks to our federalist system of government, you've got a federal overlay, but you also have potentially 50 other jurisdictions that their system of laws and regulations are going to apply. And
for those of you who may be thinking, well, we're tax-exempt organizations, so this doesn't apply to us, of course, we're not talking about corporate income tax, because except for unrelated business income, you're not going to be subject to corporate income tax. Although that could come into play to the extent you have unrelated business income. That is very much not only a federal issue, but it's a state issue, a state income tax issue as well. If you have employees in certain states that trigger the obligation to pay corporate income tax, that will apply in connection with your unrelated business income in being taxed in that state. But what Dave's referring to, I think, principally is payroll taxes, right, from which there are no exemptions for nonprofit tax-exempt organizations.
Yeah, and I'm actually going to keep going just because I'm mindful of the time, but a real quick comment on the unemployment. That's an issue that rises constantly when you have remote workers who lose their jobs. And that's very common how the issue of the taxation and the payroll issues come into play. And there's a case that I was reviewing preparing for this. It was a woman who worked in Florida full-time for a New York company, was terminated, filed for unemployment in Florida, didn't get relief there, so she filed for it in New York. And that was another case that went all the way up to the New York Supreme Court as they were trying to sort through the issue of which system of laws should apply. So the unemployment issues, where you're making contributions, where you're not making contributions and the like are ones that need to be looked at and fleshed out, particularly if you have multiple employees, because it can get to be rather spendy and no one wants to get sideways with any state government, because once they're in your operations, they can do a great deal of harm to you. But with that, I'm going to go ahead and turn it over, I believe, to Christine about tort liability. The result of the New York case, I believe, and I should know because I read it this morning, I believe ultimately that she was denied in both jurisdictions. But for me, the telling portion of it was that both systems took it up. And both systems fully vetted the issue, and so the employer had to go through both systems. Ultimately, it was a denial, but
So she paid the unemployment insurance in both whatever jurisdiction had zero coverage?
But it wasn't zero coverage. I believe the issue in that case, the question was, did she pay and was there coverage? I believe the issue turned on whether or not the circumstances of her discharge made her not eligible to receive benefits. So it didn't have anything to do with which system that they were paying into. Ultimately, it turned on the specific circumstances of her actual discharge. So.
Two really quick points here. We're going to discuss tort liability, and then the next slide is on zoning laws. I just want to spot the issues for you because I know we're short on time, and we want to get to what you should include in your policies and what you should certainly include in any sort of telecommuting agreement that you get into. But tort liability, generally speaking, it's employers that have primary responsibility for injuries to third parties and damage to property that are caused by employee negligence. And this is especially true when you're dealing with the employer's premises, but it's not entirely clear when you're dealing with the employee's home office. Example of this, you have a certain courier just delivering a package to the employee at home. It's a work-related package, and the courier trips and falls. Whose responsibility is it? So just make sure to protect yourself from these kinds of claims, make sure that your liability insurance covers the employee's home whenever it's being used for telework. Two other reasons for this that I just want to point out. The employee's homeowner's insurance likely does not cover torts that are going to be committed during the course of a telecommuting arrangement. And some states actually require employers' liability insurance to cover telecommuting employees' homes. Really quick policy consideration, you might want to consider requiring telecommuting employees to maintain this extra insurance, again, if it's going to cover that kind of work. Zoning laws. Many cities have zoning laws that limit or restrict the operation of a business in a home. So in most cases, the laws are going to require that an appropriate permit or license is sought and obtained to operate a home business. So again, policy consideration here is under these circumstances, you need to consider whether or not it's going to be you that's responsible for obtaining the appropriate permit or license, or if it's going to be the employee. And if it's the employee, whether or not you should require an inspection of those documents. So at this point, just wanted to transition the program to discussing must-haves in any telecommuting policy, must-haves in any telecommuting agreement. Both of these documents would be in writing. And just the distinction between the two, the policy is going to be what appears in your employee handbook or on your intranet. It's the standalone document that explains, whether or not telecommuting is an option and what the process is for an employee who wants to consider telecommuting. The telecommuting agreement is going to be the document that you have with the individual employee who's already been granted telecommuting. So at this point on this slide, I'm just going to discuss points that you should certainly include in any telecommuting policy. You need to include a clear definition of telecommuting. What is it? Is it only work at home, or are you also going to consider other off-site locations? Your policy should also contain a clear definition of eligibility requirements. This might include something like minimum length of employment. Is it 12 months? Do you need to have on-track performance before you'll be considered for telecommuting? And perhaps you outline the successful characteristics of the telecommuter that we discussed earlier. The other thing that you would want to include in any policy is information on how to identify telecommuting eligible positions. By way of example, this is a statement that I included in a recent policy. I'm just going to read it to you. Something like this would be appropriate. Not all jobs can be performed from off-site locations. In general, positions requiring face-to-face interaction with customers and office personnel are not suitable for telecommuting arrangements. Before entering into any telecommuting arrangement, the employee and his or her supervisor and manager will evaluate the suitability of the arrangement, paying attention to the following areas: company and department goals, employee suitability, job responsibilities, output and performance, supervision and accountability, equipment needs, workspace, design considerations, and scheduling. That would be an appropriate reflection on how you consider whether or not something's telecommuting eligible. The other thing that you want to include in your policy is the procedure for an employee to follow when they want to pursue a telecommuting arrangement. Is there an application? You probably should have an application. What are the various approval levels? Is it going to go up to the manager first and then to HR for approval? You want to include that. You want to include any timelines for approval and denial, and outline any training requirements that might be expected. And certainly you should include an expectation that the employee will have to enter into a written telecommuting agreement. Definite must have the written agreement, as we'll discuss later. It's going to set the expectations of the relationship, and it'll be a written record of the agreement, and certainly might be helpful in the event there are any disputes later on. So on this slide, I discuss must-haves in any telecommuting policy and any telecommuting agreement. Any policy or agreement should emphasize that telecommuting is an arrangement established first and foremost to facilitate the accomplishment of work. It should also emphasize that the right to telecommute is not an entitlement and can be revoked at any time. And to this end, we typically advise that telecommuting arrangements be made on a trial basis, maybe for 3 to 4 months, noting that the arrangement can be discontinued at any time, not only at the employer's choice, but also at the individual's choice. And my recommendation here too is if you're going to do a trial period, it should conclude with an evaluation of the telecommuting arrangement so that recommendations for continuance or modification could be made for moving forward. Any policy and contract should also emphasize that the abuse of any telecommuting privileges can result in termination of employment. You'll also want to indicate that the organization expects that the employee will be required to meet the same performance standards as on-site employees. You'll also want to outline the expectation that the employee is responsible for ensuring a safe work environment, reporting work-related injuries, and again, if this is something that's included in your policy, obtaining insurance for injuries to third parties. In addition, some of the items that we discussed earlier that you'll want to include in any policy and agreement is the employer's right to monitor and inspect the work site. You'll also want to address those non-disclosure and confidentiality issues. And you'll want to outline a process for the return of company property upon termination of employment. The last thing you'll want to include is a statement in there that says your organization has discretion to unilaterally impose additional terms and conditions on the telecommuting arrangement moving forward. And finally, these are just must-haves in any telecommuting agreement. We're not talking here about the policy anymore. Ultimately, as I mentioned earlier, this agreement is going to dictate how the arrangement's going to work. This is a roadmap of expectations, so be clear and be specific. You're going to want to outline in here the responsibilities of the telecommuting employee, including with compliance, of all policies and procedures of your organization. You're going to want to outline the responsibilities of your supervisor or manager who's overseeing that particular employee. You're going to want to outline the expectations of communication, whether it be between employees and supervisors, employees and their coworkers, and employees and customers and clients. This also just ties in with keeping your telecommuting employees informed and involved. I mean, this is important because traditionally when we think about communication in the workplace, there's a lot of face-to-face interaction. So that needs to be supplemented so that if you have telecommuters, they don't feel like they're forgotten when they're working off-site. You're going to want to include specifics about the employee's work schedule. This is going to include certainly a policy and the expectation on overtime work, as well as reporting requirements. If the employee is splitting their time between the office, the regular office, and the home office, you're going to want to outline that schedule. But certainly if the employee is spending most of his or her time at the home office, and maybe he or she may come into the regular work site a few times a year, you're going to want to outline those expectations as well. If you can't be specific, a statement that the employee will report to the office as needed or as required for meetings, trainings, or as requested by the supervisor, that would be sufficient. And finally, you're going to want to outline in this agreement the levels of support, the materials and equipment that the employer is going to provide to the employees, what the employer is not going to provide to employees, and maybe how those costs are going to be shared. I know the obvious is here as we talk about the computer, we talk about supplies, maybe reams of paper, but there's also going to be some hidden costs here too to telecommuters. They're going to save on those commuting costs, but they may also see an increase in their electric bills because they're now working from home. That's something that you'll also want to address in the agreement.
I think one last thing that should always be in the agreement, and I just want to reiterate what was in the prior slide, and that's a very clear acknowledgement that the existing of the relationship is at the discretion of management. The telecommuting arrangements, even if they're started on a temporary basis, have a very notorious habit of becoming permanent. And one thing that often happens is you have one manager that's comfortable with the telecommuting relationship, and you have a new manager that comes in, and they might be a FaceTime person, and they want to have their team in the office. And so that's perfectly legitimate, so long as it's being imposed across the board in a non-discriminatory manner, and you want to have that tool of being able to go back to the agreement and saying, this was the deal that we struck at the beginning. It was always understood that this was discretionary and could be ended at any time. So that keeping that discretion and keeping it our choice to have the telecommuting relationship is essential.
Okay. Just keep it open here for a couple minutes for a few final questions, and then we're going to need to wrap up. Yeah, back there in the blue shirt.
We have a bunch of hourly employees who do their personal device and they're accessing our email at all various hours of the night. Some of them support international staff, so it's a great need for them, they say, to be on the clock and check their email. Can you just think about any issues that we might have with that?
The question is issues concerning employees that use their own devices and communicate really potentially at all hours with other coworkers or clients, some of which are here in the United States and some of which are located overseas, and any issues with that. And hourly workers. The short answer there is that there are enough issues in that hypothetical for us to talk for quite some time, I'm afraid. I mean, the ones that leap to mind are going to be the wage and hour ones, meaning that there's a difference between waiting to be engaged and engaged to be waiting. If I'm engaged to be waiting, then all of the time that I'm sitting there is compensable. If I'm waiting to be engaged, I'm only actually working and entitled to pay when I'm actually working, when an email comes in. And the line between those is very blurry. And I mean, where this really comes up is with IT staff and the like, because as you described, they might be supporting a 24/7 operation, and those dollars can add up very quickly. In addition, you've got the full overlay of all the confidentiality issues that we talked about if they're using their own personal devices. Those are devices that you can't control as well as you could if they were sitting in the office using your network and the like, so you would want to have policies and agreements in place. But what you describe is becoming ever more typical, and it is challenging.
One more question, then we're going to have to wrap up.
We were talking specifically about, oh, sorry about that. The question was if you're dealing with a senior employee, is the D&O insurance going to cover that? Again, I can't imagine, just based on the terms of a typical D&O policy, that it's going to cover it. You should certainly look at the terms and discuss with your carrier whether it's going to cover it. But my expectation there is that you're going to need to obtain additional insurance.
Yeah, and don't just focus on D&O. I mean, D&O may be the least type of policy where you have to worry about exclusions for where employees are working, although you certainly may find some. But more things like commercial general liability insurance, kind of the slip and fall insurance, in addition to, of course, other types of employee-specific policies. But those are ones you're going to want to focus on as well. I want to thank our panelists for a terrific program here today. I want to thank everyone on the phone and here in person for participating. As I indicated earlier, a link will be sent out to all of you, both in person on the phone tomorrow, with a link to the recording of this session if you want to share it with colleagues, as well as the PowerPoint presentation. And we hope to see you here at our next seminar next month. Thank you very much. Have a good afternoon. Thank you.
Thank you. Please stand by.